Mannion. I'll be your courtroom deputy this morning. We will have Judge Richardson, Judge Hyten, and Judge Moon on our first case. Judge Moon is remote, and we have the monitors for that. But for all the cases, even though we'll have a panel switch and Judge Moon will be leaving us, we will have our timers on the monitors. Your time will start off green. As you have 5 minutes remaining, it will turn amber. And when your time has ended, it will turn red and start counting up. We ask that at the time it turns red, if you stop, ask the lead judge, Judge Richardson, Judge Richardson in the first panel, if you may continue, and he will tell you what to do. In the second panel, it will be lead judge, Judge Wynn, Judge Richardson, and Judge Hyten. The second and third, I should say, for the second and third cases. There was counsel who requested 3 chairs at council table.
We had done that.
Okay, so that is appellee in the third case.
But that's not critical, so.
It shouldn't be an issue as long as Mr. Shepherd, we only have 1 person at council table,
Yes.
so we can move the chair.
Okay.
Not happy with that. We do ask that you mute, silence all of your electronic devices. You are allowed to have electronic devices at council table only for your argument at hand. Let's see, are there any last minute questions for me? Sorry, backing up. We will have a brief recess after the first panel so that we can get the panel shifted Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Have a seat. Welcome to the Fourth Circuit. I particularly want to welcome and thank our good friend Judge Moon, who is joining us by Zoom. We appreciate his willingness to do so, and though we hate he's not with us, we're glad he's joining us. We're going to hear, with this panel at least, one case, 24-1656, Oliver versus Navy Federal Credit. Mr. Schwartz, we're happy to hear from you. Whenever you're ready.
Thank you, Your Honor. Good morning. Good morning. May it please the court, my name is Daniel Schwartz. I'm representing plaintiffs in this matter. The 9 named plaintiffs here aren't meaningfully different from others who seek loans from Navy Federal Credit Union. Like everyone else, they submitted a prescribed set of materials regarding their creditworthiness to Navy Federal to get a loan approved. And as it does for everyone else, Navy Federal evaluated that creditworthiness using its standard proprietary underwriting algorithm, its creditworthiness evaluation process.
So just to connect this to the complaint, were you just starting with paragraph 64 and are now pivoting to paragraph 67?
That's exactly right.
I just want, because the question we're assessing is whether the complaint's sufficient, not whether a bunch of representations you now make to us at oral argument are sufficient.
Absolutely. As described and as alleged in paragraph 64 and 67, there is a standard set of materials given to Navy Federal, and there is a standard underwriting process that Navy Federal undertakes.
Just on a factual basis, so you say there's a standard set of materials in 64, but then in 67, you say they take that information, but also other information,
Well,
right? That's unspecified or unknown, and it sort of goes into the box, as I understand it. And then in 67, you explain that after that algorithm makes some determination, then, and only then, presumably an individual, a loan officer, decides whether to lend to the borrower and at what rate. And that's why you describe this as a, quote, somewhat automated process.
Well, Your Honor, Navy Federal has not yet disclosed to us. We don't yet
We're looking
have-
at the allegation. So you alleged it's a somewhat automated process.
That's right.
And you described that the application information and other information that unspecified is put into an algorithm, and then Navy Federal, using the loan officer you talk about in 66, decides whether to lend to a particular borrower and on what terms. Like that's the process, this overall process that you've described. Doesn't look exactly like what you allege in the brief, but we got to rely on the complaint.
Yep.
That's where we should look for the process that you've described. Is these paragraphs
64 to 68.
67.
I think 64 to 68, thereabouts. That's right, Your Honor. But I will note, I don't believe that we describe some overriding discretion of a given loan officer anywhere in the complaint.
Well, but you say in 63, right, that there are 2 ways of doing this, right? One is a manual discretionary process, and one is an automated process, or a combination.
That's right.
And then in 64, you say they do a somewhat automated process.
That's right.
Which means a combination, right, of discretion and automation, right? Those are the 2 options you've given us. I'm just reading your complaint. I understand your brief wants to tell us a different story, but that's what the complaint says.
Well, Your Honor, I think what the complaint says is, as certainly as it's intended to say, what the complaint says is that there is a semi-automated process. I think that's absolutely right. And what portion of that discretion is wide-ranging, what portion is very narrowly tailored with respect to those individual loan officers, is not yet known to us because we have not yet been in discovery. And I think that is
Understand
evident
that
within
the
the
amount
complaint.
and nature of the discretion is unknown. I
Okay.
totally accept that.
Okay, thank you.
I'm just
Your Honor.
trying to understand what the process that we have is.
I think it's exactly as you described. There's a semi-automated process. The amount of actual discretion that a loan officer may or may not have, we do not yet presently know because we do not know. We do not have all the details with respect to Navy Federal's underwriting policies and process. We've asked for them in discovery. We hope to get them when we go forward.
Step back before we do this? And
Sure.
ask you a little bit about, you say in your reply brief that the district court here permanently struck your class allegations?
That's right.
So I don't read the rules that way, and so I want you to help me understand why you think this is permanent. So 23D2, so this is, in my view, a 23D1D order, right, requiring you to amend by removing these class allegations?
That's right.
Right?
Because, just so I can clarify, just because although Rule 23F is thrown around, this is obviously not Rule 23F. 12F. This is
mean
not
12.
scandalous,
No,
voluminous. That's not why Judge Brinkema struck these allegations, because they were scandalous or voluminous or proposed proprietary information.
I agree.
Okay.
Okay. So, but 23D2, like, tells us expressly that this type of an order can and may well be reconsidered and combined with Rule 16, other case management type decisions, right? That's what 23D2 tells us.
Sure.
And so, why then do you claim that this is a permanent denial of class? It doesn't strike me at all that that's what Judge Brinkema was doing. She seems to be exercising the standard sort of like case management type discretion that Rule 23 provides her.
I don't think I agree with that, Your Honor, because
So
to
tell me
strike,
why.
I will. To strike class allegations under 23D2, the court must find as a matter of law that there is no possible set of facts
All right, so why?
that could
so
be elicited.
I don't think that's true, and I don't know where you're getting that from. Out of the rules. The rules don't seem to tell us that at all, right? So the rules seem to say that this is like a case management type discussion, right? And so the district court, Judge Brinkema, is able to evaluate the allegations you've made and say in her discretion, right, whether this is a case that ought to go forward with class discovery and the class action process and all the challenges that come with that at this point or not. And if information develops that allows you to provide more specificity or allows you to explain how a single policy as opposed to some broad process applies, then D2 tells us that the court should reconsider that.
Although-
but that's part of the district court's broad discretion to control the manner of litigation before her court.
But what that I think effectively can do, Your Honor, what I think it effectively can do is cut out the possibility of eliciting the very discovery that would show that class litigation is plausible here.
So that is entirely possible, that when a district court judge exercising their discretion provides effectively limits on discovery, that might make your life harder. I totally get that, right? That's a reasonable limit. Anytime a district court judge makes case management decisions, those are can have consequences. I totally acknowledge that. But that's why we give district court judges a great deal of discretion in the class action context and otherwise to run their own courtrooms and manage the process.
But if I may, Your Honor, what that could do is it could allow a district court to effectively take away the ability of claimants to prove up any Rule 23 cases if they think at the outset of a case that it is ultimately unlikely for a class to be certified down the road.
And that's why we're here, and we've given you an appeal, right, under 23F to evaluate whether the district court judge abused its discretion in making that judgment. It's not that you get no review, right, but this is not a question about whether it would be impossible for something to happen, but instead whether Judge Brinkema, who, is not new at this process by any stretch of the imagination, is entitled to sort of use her discretion to manage the process.
Well, I want to point out, however, Your Honor, that under any standard, whether it's a de novo review or an abuse of discretion review, the striking of class allegations here, given Judge Brinkema's finding of a plausible disparate impact with respect to the individual applicants, would represent an abuse of
But
discretion.
we don't review that. So if that decision was right or wrong, it matters not to us. We don't defer to that decision. Judge Brinkema might have gotten the motion to dismiss wrong. That's totally fair. But we don't have the authority to review that. We just review this question.
Well, precisely, Your Honor, and precisely. And having found
Well,
that
Judges don't make findings on ruling on motions to dismiss, right? Concluded?
Thank you, better word. Having concluded.
But do you think
that
this court
plaintiffs-
has to accept that conclusion is correct?
I think the court doesn't necessarily, I don't think the court's evaluating whether that conclusion's correct. I think the court
Right,
is starting from the premise that that conclusion is correct.
Wait, what's
This
that?
court is?
Yes, because
Why?
because Judge Brinkema's order saying that under no set of circumstances could a plausible class claim survive is in
Tell me where in her
fundamental.
order, tell me where in her order she said, I didn't see that in her order.
Well,
You just quoted her order saying something that I don't think she said
Well,
at all.
I should say, her order striking the class allegations.
Did not say that, right?
No, of course it didn't say that. What it said, Your Honor, was, what it said, Your Honor, is that it was striking the class allegations because, quote, excuse me, I can pull up the exact language, but the process is too varied. That's what she said. She made
That's not exactly what she said either. I mean, I can pull it up too, but it seems like to me, like, I understand that you want to rewrite your complaint, but one thing we definitely can't do is rewrite the judge's order, right?
Your Honor, I will pull, I agree, I should say the exact language in her
Well,
decision.
in fairness to you,
order, right.
does Judge Brinkema not say at page 95 of the JA, this is not a case that is appropriate for class certification? Does she not say those words at the hearing?
She did.
Yeah.
She did. She
Yeah.
did. That's what she said. And what I'm saying is that finding right now
But when she
is in
struck, what she
fundamental
said is that this
tension.
is for judicial efficiency, right? That you haven't shown sufficient commonality, that I'm going to strike them for judicial efficiency.
Well,
Like, that's the context in which she's sort of saying this.
I don't think she spoke those words either, Your Honor. I don't think she said because of a want of commonality. In her decision itself, and if the court will grant me just one moment, I'm going to pull up the exact language right now.
Well, while you're there, she also says at J98, this can't possibly be an appropriate case for class certification.
Yes, she did. Thank you. That's exactly what she said.
Right, that's
she said-
at the argument.
At the argument.
Right, and that's the judgment that she's making under 23D1D.
What she said in her decision, her memorandum, was, and this is on JA 122, because the circumstances of each plaintiff's loan application process are so varied, and to promote the efficient use of resources and to streamline the claims to be considered in this civil action, the court will strike the class allegations and allow the 9 plaintiffs to proceed. Now, I will note that so varied evaluation did not come out of a reading of the complaint. It did not come out of an argument made by opposing counsel. It was Judge Brinkema's own fact-finding, her own assessment. And what I am saying to this court was that was an inappropriate evaluation. And it was also in fundamental tension with Judge Brinkema's finding that the plaintiffs had stated a disparate impact as to themselves.
I have one question on that.
Yes.
Again, you're positing that we have to posit that Judge Brinkema was right to not grant the motion to dismiss in its entirety. And I'm not sure why we have to posit that. Let me just give you a reason I think that. You could litigate this case all the way through final judgment. We could reverse right now. She could certify a class.
Yes.
You could litigate this case all the way through to final judgment, and we could on appeal say, actually the district court should have granted the motion to dismiss the entire complaint, right? We would owe her no deference at all on that question.
I suppose that's true.
So why do we owe her deference now? Why would we owe her deference now on a question that we wouldn't owe her any deference later?
Because the fundamental question that I think we are facing, and perhaps we are going in circles with this, Your Honor, but I think the fundamental question that we are facing is whether, given her assessment of the case, whether it is appropriate for her to find, and I do contend, Your Honor, that there is implicit in her order a finding, and explicit in her statements, implicit in her order, a finding that there is no that no amount of discovery would allow.
Can I take you back
a
to the
plausible
complaint?
case. Absolutely.
This is the top of 46, it's paragraph 67. How much work are the words, its proprietary algorithm singular doing? So what if they had said its proprietary algorithms? Like,
I don't think it's doing I don't think the singular versus the plural is doing a whole lot, if
Okay.
I'm being, I mean, I think whether
you'd
it's
agree
a
it would be
single.
worse for you if it said algorithms, right?
I mean, perhaps, although then we're getting into a bit of a
Would it be
semantic.
plausible to think that they're doing the same thing for all 4 different products? I mean,
Well,
if you said one, we know, like, they would be violating federal law, because they have to take things into consideration in some that not in others. And so, like, that would be odd to think that it is actually a single algorithm.
I have two responses to that, Your Honor. Number one is that for any given product, there's going to be a credit evaluation process, which could very well be a singular credit evaluation process for any given applicant. And number two, that differential between types of loan products
Just
could
an
be.
example. In the same way that if, like, say you want to work for the federal government in an enormous variety of jobs, you have to fill out an SF-85.
That's exactly right. That's exactly right. Thank you, Your Honor. And the second is that difference would, I think, be cause for creation of subclasses later. If it turns out that applying for a 30-year loan is evaluated absolutely in no way like applying for a HELOC or applying for a cash-out refinance, then we could trim the classes, we could create subclasses, we could do something like that. It is not cause for tossing out everything. One thing Judge
Can I just
Brinkham
ask one question, then I want to be sure to ask Judge Moon if he has questions? What do I look for the authority is that if the class was improper because it lacked commonality, that the appropriate remedy is to permit you to create subclasses? So we would reverse the district court because you could later create subclasses? Like, I guess I'm having trouble understanding that argument.
Well, Your Honor.
If it's not common, but you may be able to create common by creating subclasses that like look alike?
I think we.
Why is that that's the answer you gave. I'm curious what we do there.
I think, Your Honor, that what we said is, and this is quoted, I think, towards the end of our reply brief, is that the court has in its discretion the ability to create subclasses, to trim.
The district court,
The district
right?
court, absolutely.
Not this court.
And right now, this court is not evaluating whether there's a proper class certification. It's not evaluating whether the commonality has been met yet. It's evaluating whether it's appropriate to strike class allegations from the face of the complaint, from what's on the face of the complaint.
Judge
Moon,
I apologize because we have not given you much of a chance to weigh in here.
Well, you've asked most of the questions. I would like to know why you just focus on 23B1. It seems to me that under 23B3, the questions here the class members do not predominate over any other questions affecting the individual members. And it seems to me that what she's focusing on is that for these plaintiffs to get relief, you're going to have to try each case separately. It's just not a good case for a class action because you have so many, no decision is really going to resolve anything for all of the, or most of the plaintiffs.
may I respond to that? I see I'm well into my overtime.
You can respond as long as Judge Moon asks you questions. You can keep answering.
All right. I think, Your Honor, that again, we're just not there yet. We don't yet have the information to know whether those individual differences between plaintiffs who apply for a 30-year mortgage will ultimately predominate here.
You know they are, from your complaint, you know that all of them had suffered different types of injuries, which would give them different verdicts insofar as their damages are concerned. You'd have, one judgment. Well, you're not going to just be able to divide up a sum of money among these people. And it's just so many combinations and permutations that it would just have to be decided pretty much the way she seems to have decided the case ought to be handled.
I don't think that's right, Your Honor, because we don't yet know. We don't yet know what the common, whether this common underwriting process is having the disparate impact across the class, whether it's only impacting this one. We don't yet have that. We only have our allegations on the face of the complaint.
Isn't that in Twombly, like, the fact that, like, you don't have the information of the agreement yet, like, isn't an answer for a failure to plead it, right? I get that it's hard, right? It's hard in this Twombly world to make these allegations, but you don't just get to say in Twombly, man, if you just give us discovery, we're gonna find the email that shows the agreement, right?
And we're not asking for that, Your Honor. What we've done is we've
But then you
shown
just keep saying,
statistically.
we don't yet have the information, like, that's not an answer to the pleading failure.
As Judge Brinkema herself put it, the statistical disparities that we were able to put forward, this is when she was talking about the individual disparate impact claims. The statistical disparities reveal a disparate impact among non-white loan applicants and the underwriting algorithm and process. The thing that all of these different pieces of input that you put in, that it then spits out an answer for Navy Federal, that underwriting algorithm and process is alleged to have caused that disparity. That is the essence of disparate impact litigation. And then we
You've got
have
some time left on reply. We'll be
I
happy
do.
to hear from you.
Okay.
Oh, I wanted to
I
ask
have
one
judges.
other.
I have one question because it relates to a question I'm going to ask your colleague on the other side. Didn't you also plead a B2 class?
Thank you, Your Honor. Yes. That was the next point I wanted to make to that in response to that. We pled a B2 class. So if it turns out, that it could very well turn out that an injunctive relief class is where we go. And a B2 class is ultimately the most appropriate here. Thank you, Your Honor.
Judge Moon, sorry, before Mr.
Well,
Moon jumps.
I mean, you can get, I agree that you pled the injunctive relief, but it seems to me you cannot have it's obvious from the allegations that you cannot recover the money damages at the same time, because you have all these individuals that will have to prove their case separately, that they were injured by the algorithm and that they have what their damages are. And that's, you're familiar with the Pilgrim case, and the Sixth Circuit said the problem the plaintiff had there was they could not even proffer what would might come about in discovery to satisfy that problem.
Well, Your Honor, I think there are 2 points that could be made there with respect to the question of whether we could ultimately prove damages. And in the end, if there's a B2 case, and that's ultimately how the class gets certified and we go forward, then there won't, that won't be part of the question that we're facing. And with respect to the Pilgrim case, I think we absolutely can proffer discovery regarding whether there is a disparate impact that is caused by this loan algorithm and whether there's a less discriminatory alternative. Whether there is, we have experts lined up who are going to come in and talk about how, looking at the way in which Navy Federal evaluates its loan application process, looking at its process and policy, it could there could be another way of creating that algorithm.
Well, yeah, that would maybe create the liability, but then seems like you run into the face of Walmart v. Duke, and you've got all these, we would have all these individual cases.
I don't think so. I don't think.
Oh.
Oh, I'm sorry, Your Honor. I didn't mean to cut you off.
Well, I've talked too long.
Not at all. Not at all. Shall I respond to the Walmart v. Dukes question, or?
You're welcome to.
Okay. So I don't think Walmart v. Dukes is quite the same situation here, because in Walmart v. Dukes, the real core problem was that the entire B2 class was based on the notion of this wide-ranging discretion amongst the various Walmart stores and it essentially said that the act of granting too broad discretion was the problem. We're arguing something somewhat to the opposite.
So it seems like to me you're actually arguing the same thing as Dukes. Because what Dukes says is you have this disparity, this statistical disparity, and what you can't do in Dukes is allege the process as a whole is the policy that we're alleging causes that, right? So that's what Walmart does. It does it also on discretion, but it says you can't allege the general policy of hiring as being the policy that creates it. And you've alleged basically the same thing. You have this significant statistical disparity, at least with respect to some groups of people and some groups of products. And then your answer to that in the complaint, as I read it, is that the entire process, what you call the underwriting process, is what causes this problem. And that type of sort of generalized policy is precisely what we said in Stafford is not acceptable for a commonality inquiry, and what the Supreme Court in cases like Ward Cove and Watson and Dukes tells us is not acceptable for disparate impact cases.
Your Honor, I have to respectfully disagree, and it's for the
I'm
following
sure you
reason.
do, right?
It's
But
for the,
why?
It's for the following reason. What we are saying here is that there is a uniform means of evaluating creditworthiness, the algorithm, as Judge Heitens helpfully pointed out, the algorithm. And it is that algorithmic decision-making, the uniform means of evaluating creditworthiness that we are saying is defective here and causing a disparate impact. And that is fundamentally different. That is a species of centralized decision-making that is fundamentally different than the broad policy that you're talking about from Dukes, which was allowing far too much discretion to, the allegations allowing far too much discretion to local decision-makers. And that is a fundamental difference.
Thank you, counsel. We'll hear from you in a
Thank
little
you, Your
bit. Mr. Volchuk, we're happy to hear from you too.
May it please the court, Daniel Volchok for Navy Federal Credit Union. Your Honors, the only question in this appeal is, did the complaint plausibly allege that the proposed class satisfies Rule 23? And I want to explain why Judge Brinkema answered that question correctly, starting with some of the points that came up.
And when you say correctly, I read your entire brief as understanding Judge Brinkema as having denied class certification, right? Not, maybe I'll come back to it later if they come up with some new fact. I guess I would say, Mr. Volchuk, would you want to walk into Judge Brinkema's courtroom and propose that you'd like to replead the class action allegations?
Well, several responses, Judge Heitens. First of all, she certainly struck the class allegations. That was the motion that we proposed. Now, to Judge Richardson's point, someone can come back on 23D and say if the evidence is developed, that decision can be revisited. A litigant can also, of course, always file a Rule 15 motion to amend. Now this is the fourth class action complaint that they have put in, so they would certainly, I submit, be within Judge Brinkema's discretion to deny that. But let's be clear, there is no question in this appeal about whether her denial of leave to amend was an abuse of discretion. There is no argument in their briefing that she should have granted leave to amend. They make a different argument. It seems slightly different, but it's very different, and let me explain why. The argument that they make, and you heard it again this morning, is she should have created subclasses, or she could create subclasses later on. That is very different. That is saying, let us pass Rule 12 now. It's akin to in a 12b6 situation. The complaint is dismissed. The plaintiff says, well, or there's a motion to dismiss, and the plaintiff says, Judge, even if we haven't pleaded a plausible claim, don't dismiss, let us go forward. You can always fix it later. You don't get to move past Rule 12 unless you have pleaded a plausible claim. And it also goes to their point about discovery. They did say again and again this morning, Judge Richardson, we need discovery, we need discovery. You don't get discovery unless you get past Rule 12, and that makes sense because as a plaintiff, you don't need discovery. You get the benefit of it.
We're just combining two things. I heard plausible Rule 12. And when you say plausible Rule 12, the one of the fewest things that I'm certain of as someone who's taught Civ Pro for many years, when we're talking plausible Rule 12, that's de novo review. Anytime I hear the words Rule 12 or plausible, because that's Twombly and Iqbal, we agree that a Twombly-Iqbal dismissal is reviewed de novo, right?
Yes, and I agree that Judge Brinkema's decision to strike the class allegations, to strike this complaint, is reviewed by this court de novo, but that is a different question.
Wait, what? I'm sorry. No. First, you can't agree to the standard of review. Second, like, you're just wrong. So 23D, this is not a 12F dismissal. Your colleague agrees with it. You can assume that this doesn't have anything to do with 12F because none of the characteristics of 12F are met here. It's a 23D1D order, and that is reviewed for an abuse of discretion. It's not a de novo review because we're not simply asking whether it's plausible. That's not what 23D1D asks. That's not what Rule 23 asks. In every context in reviewing a Rule 23 decision, we have reviewed it for an abuse of discretion. I'm not aware of any court that's reviewed a Rule 23 decision de novo. And so you're welcome to sort of go down the road, but help me understand why you think a Rule 23D1D order, which is what we have here, is reviewed de novo.
So Judge Richardson, I am certainly not going to be in the position of arguing for a less deferential standard of review when I am defending the district court's decision. If the court views this as a 21D1D, so be it. The parties have briefed this as if the question is the complaint plausibly alleged satisfaction of Rule 23? And I don't think...
And you did that, I take it you did that because you think it's a Rule 12F order? I mean, why? Help me just so that maybe I don't want to get it wrong, right? And so you're an officer of the court, you're good at this, right? So you seem to assume that this is a Rule 12 question, right? Why?
Because
Why is that?
Well, you're making me uncomfortable
I
here,
know,
Judge Richardson, but that's
you're an
okay,
officer
that's
of
your
the court,
job.
right? Help me understand, like, why in the world would we think about this as a Rule 12 question?
So we filed a motion to dismiss and a motion to strike. Those are, in the Federal Rules of Civil Procedure, put under Rule 12, and we have cited cases that analogize a Rule 12F motion to dismiss class or to strike class claims as analogous to a 12B6. I think you get to the same end result, whatever the court decides is the proper procedural framework. The point is, this complaint...
Do you think that the district court properly found that one of the 4 reasons, like that it's scandalous or frivolous or what, the 12F standards, like, don't remotely seem applicable here. If we're really reviewing this under Rule 12, like, you face an impossible hurdle, right? Because, like, one thing I can say is, like, they're not sufficiently scandalous that we need to strike them, right? They're not, like, inappropriate pictures or things, right? We're in a very different world than what 12F seems to be.
I agree with that, Judge Richardson. Courts have, through path dependency or otherwise, looked at these sorts of motions saying this class claim cannot proceed forward through the rubric of 12F, notwithstanding the misfit between the language of 12F you just identified and the substance of the allegations here. I don't mean to get sidetracked because, as I say, I think you get to the end result, the same end result, no matter what framework you look at it in.
Even under abuse of discretion, it is necessarily an abuse of discretion to make an error of law, right?
Correct.
And so if we were to conclude that you can't strike class allegations that meet the Twombly-Iqbal standard, it would be an error of law to think that you otherwise could, right?
I'm sorry, I missed that question, Judge
If we
Hytens.
think that you cannot strike allegations at the pleading stage that are sufficient under Twombly and Iqbal, that that's not permissible, then a district court who did that would have committed an error of law, right?
Yes.
And we also reviewed de novo whether allegations are sufficient under Twombly and Iqbal.
That's right. This is why, as I say, ultimately we are getting to the same, I think, standard of review, certainly to the extent the court is agreeing that the question is whether a plausible class claim has been pleaded here. And the answer is...
But another way of taking Judge Hyten's question is the first sentence he said there is, if you cannot strike if it doesn't meet Twombly, is just to say, if we apply Rule 12 instead of Rule 23, then it's de novo.
Correct.
Right? Those are just the same ways of saying it, right? That if we apply Rule 12, then it's de novo. If we apply Rule 23, it's abuse of discretion. And this seems to me to be a 23D1D order, not a 12F order.
And I think you get to the same result either way. The bottom line is this complaint does not comply with Rule 23 for a number of reasons. And let me start with commonality and Walmart versus Dukes. The Supreme Court explained in Walmart that commonality requires the plaintiff to show that the class members, quote, suffered the same injury, end quote. That's page 350 in the U.S. Report's opinion. It goes to what I think Judge Moon was talking about in the topside argument. The complaint here expressly alleges varying injuries. Some class members are alleged to have had their applications denied. Others alleged to have had them granted, but on less favorable terms than plaintiffs say they should have been. And still others alleged to have had them granted not on less favorable terms, but more slowly than plaintiffs say they should
So
have
can
been.
I ask you the paragraph 64, 67 questions I asked your friend on the other side? Why, I agree Walmart says you have to have a common injury, but it says you have to have one common injury, not that you have to have all the same common injuries, right? And so why can't I read this complaint as saying, at least potentially saying, every applicant has to fill out this form, that's 64, and then 67 says the information for everybody is at some point fed through a proprietary algorithm, that's the carryover from 45 to 46.
So
And then the argument, sorry, just the argument is,
course.
that algorithm has a disparate impact on race, which means that every decision is infected by a step in the process that discriminates based, that has a disparate impact based on race.
So I want to be clear, Judge Heitens, whether the complaint plausibly alleges that the source of the injury is a single policy and whether there is a single injury are two different questions. So I hope to have a chance to come back to the Walmart common injuries question.
Sure.
But to answer your question about a common policy, our position is that the complaint, unlike their briefing, as I think Judge Richardson was articulating the contrast, does not allege a single policy, and if it did, and I'll explain why, if it did, that would not be plausible. So the complaint is read as a whole. Now, if you look at the commonality paragraph, paragraph 249.
Oh, no, I know why you want to talk about the commonality paragraph.
Then I'll come back to these paragraphs. Paragraph 67 is talking about a single applicant. So it is talking about a single algorithm. Once Navy Federal has deemed an application complete, it runs the data from the application. Of course, we are not disputing that for each individual applicant, that, or at least that it's been plausibly alleged.
You're not conceding it's true in the world.
Thank you very much. That there is a single algorithm. But the question is there a single policy applied across all of these very disparate class members? The answer is no, number one, because of the reasons I mentioned a moment ago. Paragraph 249 refers 7 different times in the plural to algorithms, processes, policies, and one other that I'm forgetting at the moment. And it's not just the commonality paragraph. The complaint refers 24 times, including in 2 different headers, to Navy Federal's policies, plural. And the only time that it refers to a singular policy, practice. If I said policy, I misspoke. Practices, plural, 24 times. And the only time it refers to a singular practice is when it uses the phrase pattern of practice, which is a Title VII, part of Title VII jargon and doctrine. So we are not cherry picking, we are not engaging in some sort of gotcha trap. They are the masters of their complaint, but they did not allege a single policy. And if the complaint were read to allege a single policy, it wouldn't be plausible for the reasons that I think Judge Richardson was getting at in the topside argument, which is that, well, there are a number of reasons. But number one, as I mentioned a moment ago, there is disparate types of injury alleged. They have not explained. And first of all, let me just cut to the chase for a moment. There is no response in their reply brief to this argument about why, if they pled a single policy, it is plausible. The only thing they say is what you heard again this morning, that this notion of an inconsistency in Judge Brinkema's opinion. There is no inconsistency, and then I'll get back to the implausibility.
Well, how about my SF-85 example?
I'm sorry, Judge Heitens, can you give it to me again?
Sure. Virtually every federal civil, let's say, thousands, if not hundreds of thousands of federal civilian employees across wide swaths of the federal government have to undergo some sort of hiring process, virtually every one of whom has to fill out a form called an SF-85. If the argument was the SF-85 has disparate impact based on race, you would have a common question, irrespective of whether DOD, DOJ, the Department of Interior do all kinds of other stuff as part of their hiring process, because every single one of those folks has to fill out the same form that, according to these hypothetical allegations, has a disparate impact.
So, but here there is no single policy that could be plausibly alleged
Well, again,
to apply.
so that goes back to your point about 67. I was saying that's my point about 67. And I take your point that 67, I take your point about an applicant, right? But putting that part aside for purposes of this question, why wouldn't that be enough if a complaint said that?
I mean, that could be enough to allege that the SF-85 is the but you don't. I mean, you don't have.
How would it cause? I mean, that in
Exactly.
Dukes,
The
in
causation.
Dukes, they all filled out the same application too. Like, there's no plausible way to imagine that an application has caused a disparate impact.
Yes, I took Judge Heitens' question to assume that, and I didn't want to fight the hypothetical, but I think you're exactly right, Judge Richardson. And here, to go back to the plausibility point, right, they talked about I talked earlier about the varying injuries. They have not explained how a single policy uniformly applied could plausibly have produced these different injuries. Likewise, the size of the alleged disparate impact in the complaint and the sources that it incorporates, the size of the alleged disparate impact varies across products. And they have not explained how it is plausible that a single policy uniformly applied would have resulted in these sorts of variations in the disparate impact. So there's not a single policy, it's alleged, and it would not be plausible if it were. Now, I do want to finish the Walmart versus Duke's point. They expressly allege varying injuries, so commonality is not plausibly alleged, just like in the Falcone case, on which Walmart repeatedly relied. The Supreme Court held there that the district court had erred in certifying a class because of varying injuries. Some class members had been alleged, some class members had not been hired by the defendant company, and other class members had not been promoted by the defendant company. And the Supreme Court said that doesn't work under Rule 23. And Your Honors, just as their reply brief does not respond at all to the argument about plausibility of the single policy if it were alleged, their reply brief never cites Walmart, even though we cited it over a dozen times more than any other case because it is so central as to why Judge Brinkema's ruling was correct. And it's not just that they don't cite the case. There's no answer in their reply brief to this independent problem of varying injuries being alleged, which...
Can I ask you, has this court ever said you can strike class action allegations at the pleading stage?
Yes.
What case?
In Goodman versus Schlesinger, well, I don't want to overstate it, so let me spell out the answer a little bit, Judge
My
Heitens.
impression was no.
In Goodman, here's exactly what happened. In Goodman versus Schlesinger, the court, as the plaintiffs point out in their reply brief, reversed the dismissal of class claims. It was pre-discovery, so it was at the Rule 12 stage, but the court said it was improper to strike them because we, the Fourth Circuit, this court, we cannot say that certification is, quote, inappropriate as a matter of law. That's page 1332.
Which again sounds like the Rule 12 standard, right?
Yes, I'm sorry, I may have misunderstood your question. I thought you were saying striking Rule 12.
No. But I'm saying, have we ever actually affirmed a decision that did that?
As a 12F motion to strike, I don't have a case to that effect, but again...
Have we addressed it under Rule 23 D1D?
This has not come up very often, Judge Richardson, to my knowledge, certainly in this court, but we have cited, for example, we cited a case in, from the District of Maryland that cited Goodman versus Schlesinger that specifically talked about this, cited other cases from various circuits, including the John case from the Fifth Circuit. All these cases recognize, yes, 12F is not exactly the right fit, but it is a Rule 12 motion, is essentially a motion to dismiss. And I don't want to get in Judge Richardson's crosshairs again. I do not mean to fight this being a Rule 23 order if that's what the court deems it appropriate. But either way, you get to the same place because there was no abuse of discretion here. I do want to talk very briefly about predominance because it came up in the topside argument, Judge Moon's questions. That obviously is sort of commonality on steroids, a stricter version of the commonality question. So for all the reasons we've articulated, if the court nonetheless were to think there was a the commonality standard has been satisfied, at a bare minimum, the predominance standard would not be
But
satisfied.
that doesn't help you about a B2 class, right? Because B3 doesn't apply to B2
I was
class.
about to say the class could not move, the case could not move forward as a B3 class, but our principal submission, of course, is that it should not move forward as a class action at all. I'm happy to take any
So
further.
if that was the only argument we agreed with you on, then we would have to send a B2 class back, in essence.
If that is the only argument, we have our
Right.
typicality argument
No,
that we
no,
also
I
haven't
understand that.
addressed. I don't want to tax the court's patience. But correct, if the court agreed with us on one and one argument only predominance, it would go back as a B2 class. Unless the court has further questions, I ask the court to affirm.
Yeah, I got a question since you're here. So I've got sort of just a macro question that I'm struggling with a little bit. When we sort of ask this question, what the policy is, the Supreme Court in Watson and Ward's Cove and Dukes says that you can't allege a generalized policy. It has to be specific. This is sort of the point we make in Stafford too. But that perpetually sort of raises the level of generality problem, right? Because we can allege a policy at a wide variety of levels of generality, from the hiring policy as a whole all the way down to a very specific input. Do you have like insight into how I ought to think about or wrestle with that level of generality problem?
Only in the sense, Judge Richardson, that I think the Supreme Court in cases like Walmart has been very clear that, look, there has to be some bite to these requirements. Now, for example, it was talking about Rule 23, commonality. You can't just say literally, well, there's any question out there. Of course, there were common questions in Walmart. Did all the women work for Walmart? Yes, they did. That wasn't enough. So the Supreme Court has made clear it has to be something that ties the class members together. So I don't have much beyond that in terms of the correct level of generality. The allegation here is, of course, a single underwriting policy. In theory, could that be enough? Perhaps. It certainly is not here for the reasons that we've articulated.
Thank you.
Thank you, Your Honors.
Before you sit down, Judge Moon, do you have anything for Mr. Volchok?
No, no questions.
Thank you.
Thank you, Your Honors.
Your Honor, I know I went way over the first time. Do I still take 5? or-
You'll get at least some of that.
All right, all right. I want to first answer a question that Judge Richardson raised in the very beginning, during my opening. Judge Richardson asked for any authority about the ability to trim classes as opposed to just saying, sending back. I just want to point the court's attention to Messner v. North Shore from the Seventh Circuit. That's 669 F3D 802. And one thing the Seventh Circuit stated in that, which of course was a fully briefed class certification motion following discovery, in reversing, was that courts can and often should, problems from class definition can and often should be solved by refining the class definition rather than flatly denying class certification on that basis. And so that takes us to what we respectfully suggest is the issue, one of the core problems here with Judge Brinkema's order. One thing she said in her discussion, discussing the forthcoming memorandum of law when we met in court, was that this was seeking to class apples, oranges, bananas, and pears, 4 different kinds of fruit, right? Respectfully, what we could, in theory, get to would be a subclass of apples, a subclass of fruit, a subclass of bananas. The solution is not to toss all the fruit out of the window. Now, I've extended the fruit metaphor long enough, so I wanted to hit...
And your theory there is that we would find it's an abuse of discretion for Judge Brinkema not to have rewritten your complaint?
No, Your Honor.
I mean, I understand, maybe you'd have had a better argument if you'd alleged sort of like apples and bananas as different classes, but like it's a little hard to say that Judge Brinkema was responsible for rewriting your complaint.
No, Your Honor. What I'm suggesting is that it's an abuse of discretion for Judge Brinkema to rule that no possible class case could possibly go forward because of a potentially overbroad class definition if discovery ends up bearing out that we do indeed need 4 subclasses, even though our allegations at the outset are there was a problem with the fruit. Right? There was a problem with the fruit. Our allegation is everybody was deemed a greater credit risk because of Navy Federal's underwriting policy, its means of evaluating creditworthiness, which applied to all the fruit. Now, we could, if it turns out we were wrong, then when we get to class definitions.
So a big part of your friend's argument was to point out that in your reply brief you ignored their Duke's argument, and I will note that we are 2.5 minutes into your rebuttal and you are once again ignoring
Thank
their
you.
Duke's
Sorry,
argument. To give you a chance for me to not draw the adverse inference against you.
Please do not draw that adverse inference against you. I will be very happy to turn right now to Duke's. One thing that my friend, Mr. Volchok, mentioned is that there has to be the glue that ties something together. That's the essence of Duke's, is that the plaintiffs were not alleging this kind of common glue tying the class together. And plaintiffs here do. They allege a single means of evaluating creditworthiness that plaintiffs argue is flawed. That's the glue.
But in Dukes, the single means was discretion.
No, in Dukes, the single means...
That was the allegation, right? The single means was discretion.
Well, the difference here is that the single means is an actual output versus the single means being discretion that's different for everybody.
Not discretion by one decision maker.
Not discretion by one decision maker. That's exactly right. And here, there's one decision maker. There's Navy Federal.
The allegation was that, like, it was, the disparate impact was to disperse this discretion.
Right.
And that's what the court said, no, that doesn't fly, right?
Right. That's exactly right, because of the dispersal. Here, there is no allegation of dispersal. Here, there's an allegation that there's a single way of evaluating credit risk, which is Navy Federal's algorithm of evaluating credit risk. That's centralized decision-making. That is the opposite of Duke's. Duke's was about decentralization of decision-making having an adverse impact. That's not the argument we make. There is no argument that if we had made the argument, let me put it this way, just to argue the counterfactual, if I may, Your Honor.
Before you do that, can you address our decision in Stafford, sort of this same, which I think goes to the same idea, right? Which is, like, you don't get to sort of assert these sort of broad, generalized areas, like the algorithm as a whole, the hiring policy as a whole, right? That you have to be specific in order to show commonality.
Well, I think the difference here is we are being far more specific than what was occurring in Stafford. What we're describing here is effectively the computer program that Navy Federal uses that accepts a whole bunch of standardized inputs as described in number 64. There's nothing like that.
One other just factual question, just to make sure that I'm reading it correctly. In your complaint, you make a reference to zip codes and
That's right.
the prior employment positions, but you have not alleged that that is the policy, right? You're saying that might be, it might not be, but you're not alleging. In other words, it might look different if the complaint said the policy here that creates a disparate impact is the consideration of zip codes by Navy Federal. That's not the complaint you
we don't have Navy Federal's proprietary algorithm, right? We don't know. So, for instance,
Right, you don't know that.
We
This
don't
is
know.
You hope to find out the agreement from Twombly through discovery.
No. I think there's a fundamental difference here because here we have an output, right, that's having a where there's far, large disparities in racial lending, right? And we have the inputs. What we don't have is the computer program in the middle. And part of when you create a less discriminatory alternative, you look at that computer program and you look at the way they're weighing the inputs. For instance, let's say they are saying 80% credit score, 10% something else, and that could have a less discriminatory alternative.
Judge Moon, sorry, I don't want to leave you out. If you got questions.
No question.
Judge Heitens, you good? Thank you, counsel. We certainly appreciate your arguments. We will come down and greet counsel, and then we're going to take a recess before we pick up with our second case.
Thank you, Your Honor.
This court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, let's be seated. We're already in session. We have two more cases to hear today. And we will begin with the case of Brown versus State. We'll hear from the appellant's lawyer.
Good morning, Your Honors, and may it please the Court. My name is Samuel Weiss. I represent the appellant, Mr. Brown. Mr. Brown was newly incarcerated at Red Onion Maximum Security Prison in Western Virginia when he went to the barber shop. The barber shop, of course, is operated by the prison. You know, it's not a main street of a small town, right? It's like the barber who is working for the prison.
Go to the legal issues.
Happily. On due process, Henderson versus Harmon, which came out after the briefing in this case, basically settles the case. So two steps on the due process inquiry. The first is, did he have a property interest in the cash in his trust account?
They took $7 from his prison officials, and your question is, to what extent does he have a property interest in it in the first instance? And secondly, did it in fact was a defect in the process?
Right. And so I think both parties agree that we're calling it 15 for these purposes, $15, because that's what he's alleged in his complaint, and defendants concede that to them it doesn't affect any of the legal analysis. So Henderson versus Harmon, as this court had done years earlier in the unpublished opinion, Brooks versus Pate, just said, full stop, you have a property interest in your trust account.
Henderson doesn't address whether there's a de minimis exception, does it?
It does not, although like several other circuit courts do have addressed the issue, it did make its claim categorical, and I do think a de minimis exception doesn't make a lot of sense in this particular context. Defendants cite some cases regarding de minimis exceptions, which in many contexts, but especially in the prison context, make sense for things like personal property or fees for certain services and things like that were relatively small amounts of money. But in a context like this, where the question is, we are punishing you and we are seizing money from your account to punish.
Normally, $15 would be rather de minimis to bring a case up to the Fourth Circuit U.S. Court of Appeals. So what is it about this case, this instance, that makes this not de minimis in the context of here?
Well, to our client, first of all, he works for a wage, if he's able to work at all, which is its own issue, that is many times lower than anybody outside the context of prison. To purchase goods, unlike the rest of us who can purchase goods from a wide variety of sellers, he can only purchase goods from the commissary. He has, we could shop around with banks. He has to put money in the trust account. And he can only work with the permission of the very defendants who are punishing him here.
Down to it, I mean, we can hear all the facts, and this depends on how the fact. Come down to the fact that he's a prisoner, and $7 to a prisoner, from your perspective, is a lot of money, given the amount that he makes per hour, given what he can buy for it, how long it takes to do it. So you're saying factually, in this particular instance with a prisoner, it's not de minimis.
Correct.
Okay. What else do you have to add to that?
Well,
So can I just
Please.
pause on that? So from your perspective, we don't really have to answer the question of whether there exists some de minimis exception. So that maybe in, in a non-prison setting, a claim for $1 might not create sufficient interest. We can just say here, whatever we want to say, whether it's 7 or 15, in the prison setting, that's real money. Even if we might not want to say that categorically. And maybe in a prison setting, a dime would not rise above the de minimis exception. But we just don't have to answer that question at all here.
I absolutely agree.
And then I presume also, we are not in a position to answer the question of what process, is due here, or what test for that process applies, given what we've got.
I agree with that. And so, that's a dispute in the brief. So, this is sort of step 2 of procedural due process, right? Like, if we have the protected interest, what's the process? And what the Supreme Court did in Wolf is what defendants in their answering brief encouraged this court to do, which is, Wolf was a couple years after Matthews versus Eldridge. It said, go to Matthews versus Eldridge, which of course is very flexible and very context-specific, and weigh every single variable and come up with a new test. And that would be a perfectly fair reading of Wolf, except that for the past 51 years, that's not how the Supreme Court or this court has treated Wolf. What they've treated Wolf as is...
But can I just pause for a second?
Please.
This argument was not passed on by the district court?
This argument was not passed on by
And
the
so
district court.
we would be a court of first review, not of review?
That's correct. Yeah.
Okay.
And so this court would obviously be justified in just reversing on the single ground. The defendants moved for dismissal on one basis, which is the no property interest, because the Sandin versus Connor test applies. And the district court ruled on one basis. And that is no longer good law in this
Can I
court.
ask you, do you concede the district court properly dismissed Brett Farmer?
Yes, I do.
And then one final question, and then I'm gonna be done.
You can ask as many as you like.
No, that was a promise to myself, not to you. Do you agree it would be different if the money, for example, was underneath his mattress?
I absolutely agree.
And that's because it's contraband?
Yeah, it's, yes, because it's contraband, and even if we were in some sort of idiosyncratic circumstance where cash was not contraband in a correctional facility, it almost certainly is
Yes.
in every context, but because in the context of prison, there's a lot of limitations on liberty, obviously, and there's a lot of limitations on property, obviously. And the concerns with cash in prison mirror those of personal property. And so I think defendants even cite a case that involved, a money order that was taken from somebody and that was held to be de minimis. But
You would say a money order in the prison context, that's contraband and therefore
Right.
no property interest.
Yeah.
It's like having a kilo of cocaine here in the courtroom.
Right.
They can take it from you and you've got no due process.
right, absolutely. Or a bottle of alcohol, or more than a certain number of books, or many other things that would be legal and sort of freely used in any other context, but that create security risks in prison. Money in a trust account does not create the security risks
So
that cash does.
The point is, you're not asking us to say that for a prisoner, money is a property interest. You're
Yeah.
asking us much more narrowly to say that the trust account is a property interest.
Absolutely.
So can I ask you about the excessive fines clause?
Yes, Your Honor.
Where in this complaint do you think is the best language that comes closest to actually pleading an excessive fines claim? Specific page, JA.
Yeah, so I would say
You'd say it wouldn't exist, would you?
I would say that given the leniency that this court has instructed to interpret, a first version of a pro se complaint in Shaw versus Foreman, which used language along the lines of, not along the lines of, used the exact language of, allegations that, possibly could convey any legal theory.
Right, I'm asking you.
Right,
what
of
allegations in this
course.
complaint possibly convey that?
Of course.
legal
So he said, he alleges, first of all, that he was fined $15 at all in the prison context. We know that he was indigent. In United States versus Bajikajian, forgive that pronunciation, it lays out factors. One of those is, am I the person who this statute was meant to protect against? He alleges this is 4647, he alleges that that he was in the prison barber, he used the language of, I was in the prison barber shop, I did not know this rule, I was instructed by a prison official to take it off. He tells, and this is around 49, he tells the disciplinary officer, I was in the prison barber chair, I didn't know this rule doesn't seem like it applies in this context when I'm, explicitly instructed by somebody working on behalf of the prison to do something.
Okay, so I have one other question on that.
Yeah.
Are you aware of any case that holds the constitutional prohibition on excessive fines even applies to prison disciplinary proceedings?
No. And on that, to be frank, and on that score, there's very little law in the excessive fines clause at all. I mean, this is, so unlike what we talked about with Matthews versus Eldridge, where there's so much law on procedural due process in prisons and how Wolf applies, this court is writing on a pretty blank slate. And so defendants are saying, well, where's the law to support these claims? And we don't have a lot. We're pointing to a general test. But of course, defendants don't have law either because these claims just haven't been raised.
Let's assume we agree with your proper right, even though there's a procedural due process error here, that I think ostensibly would relate to the exclusion of evidence here. We said in
Yes.
Henderson that the harmless error review can apply to these cases. So
Mm-hmm.
where is it that this excluded error that you claim here, how would it have harmed you? Where did you assert that?
Right. So of course, this is a pro se complaint that needs to be read very liberally. Harmless error unquestionably applies. And in Henderson, what we had is,
How?
Pardon me?
That was a good conclusion. Harmless error unquestionably provides.
yeah, well,
The question is, how does it provide to this case?
right. So just to analogize to Henderson, because that's an example of when harmless error does apply. Henderson was a case where the incarcerated person conceded that he had done the thing wrong and was just saying the amount of money is wrong. I'm contesting this. And the court was able to look at documents because it was reimbursing medical costs and just said, no, the amount of money is not wrong. So that's harmless. Here, what we have a case is we don't have the exact language of this rule, and of course, it's inherent in a due process violation that we don't know exactly, he doesn't know, Mr. Brown doesn't know exactly what testimony he could have elicited, but he very diligently pursued his opportunities to try to put on testimony from witnesses, and if it's the defendant's contention that if, for example, the barber had testified and said, I shave 100 guys a day, and nobody's ever gotten fined before. Nobody's ever told me I shouldn't be doing this.
Wait, why would that even matter?
Be-
Right? I mean, if you drive home today and you get pulled over for going 3 miles over the speed limit, right? It's not a defense to say nobody's ever been pulled over for going 3 miles over the speed limit.
Well, that's true, but I think
This is
right,
the harmless
right,
point.
yeah,
What?
no, I
so
understand.
what, right? He got hammered for a violation that everybody thinks is a little laughable, but it's still a violation, and that doesn't make it a due process problem.
I would say it's actually unclear if it's a violation, right? We don't have a regulation, and we just have a memo which he never saw. And I think if there was testimony, prisons have hundreds of rules. They're violated often, and some of those violations are really dangerous, and some of those are perfectly innocuous.
Right, but
And the disciplinary hearing,
Who's this burden on? Is
the burden is on defendants.
and not on the plaintiff to show that the excluded evidence would cause harm? So it's a whole question of whether or not this is an affirmative defense or whether or not it is a matter that is a pleading requirement.
I don't think it's a pleading requirement, but I think it's the burden on the defendants to say, we violated your due process rights, but it wouldn't have made a difference anyway. And I think you need a clear circumstance like
Why wouldn't it be on the
Henderson.
plaintiff to say, you violated and here's the harm?
Well, I think he's shown the harm in that.
Shown, you're not alleged it, you're not put it forth anywhere.
I think he has shown the harm. I think we
But-
don't.
But what is, that, go back to Judge Wynn's question. What is the harm? proffer it to us. All right, so 99 people didn't get cited for this. Like, I don't see why that's a harm. Like, if that evidence came in, like, that has no effect on the outcome. So why, help me understand what it would be that
Your Honor,
it would matter?
So I don't actually think that's right, in the sense that disciplinary officers are not sort of a mechanical algorithm. They are exercising judgment about whether people have violated a rule and then what the proper punishment is. And so the idea.
That's true of the highway patrolman, right?
It's absolutely true of the highway patrolman.
And so
Yeah.
if he violated the memo, doesn't matter, like, you can't say, well, I didn't read the sign,
Well,
right? So like, yeah, it's true, like, nobody gets pulled over for going 2 miles over the speed
Right.
limit. But if you did and you got fined for it, you couldn't come in here and like call every 99 people that were driving in front of you and didn't get pulled over for going 37 and 35.
I mean, I think there are some differences, just in the sense of, he didn't choose not to read the sign. He was not provided with the information. And again, we don't know the exact language and whether it'd be a fair reading. But I think in harmless error, what we're doing is we're actually saying, as an empirical matter, would it have affected the decision maker? And so here, again, there's a lot that we don't know because this was dismissed on incorrect grounds. But
Let's hear from you on rebuttal when you come back. You got
Okay.
some time coming
Okay.
back up here. You go.
I'll try to address that, Judge Richardson. Thank you.
All right, you may proceed.
May it please the court, I'm Graham Bryant, Deputy Solicitor General of Virginia. On behalf of the defendant prison officials, with me at council table is Assistant Solicitor General Meredith Baker. Brown received a minor fine after notice and a hearing during which he admitted to violating a prison regulation designed to prevent the spread of the COVID-19 pandemic in the early days of that pandemic in the prison environment. The minor punishment fit the offense, and it did not offend the Constitution.
That all sounds like an argument he got the process he was due, not that he wasn't deprived of property.
So even if he was entitled to process under the situation alleged here, he would have received all the process that he was due.
But that's
this
not the
court-
basis the district court ruled in
No.
your favor, is it?
It's not, and the court need not go that far, because even this court's recognition in the Henderson against Harmon case that all prisoners have a property interest in their trust accounts doesn't affect the sort of de minimis interest affected here. That case obviously involved over $5,000 of restitution, 180 days of good time being revoked, the sorts of serious offenses that no one would question were not de minimis.
So do we look at de minimis in the context of where it is? I mean, you know the facts of this case. I mean, $7 doesn't mean much to most of the folks in this court right now, but $7 could mean a lot to a person in prison who makes what, a few pennies an hour, 27 cents an hour, or has to pay $1.50 to make a phone call, and takes so many hours to even make it. I mean, do we really need to go there in terms of whether this is de minimis in that context? There are cases in other circuits that address this very situation here. So it's one thing, we could all just, if we just said $7 or $15, that's de minimis, I would agree with that. But in a prison context, don't we have to consider that in determining whether that's de minimis?
Certainly. In the prison context, the Supreme Court has, across its procedural due process jurisprudence, said you look at what happens in a prison and not what happens in the outside world. But even here, the $7 fine out of a maximum of $15 that was imposed.
What does that mean? I don't understand what that means. You look what happens there and not in the outside world? So you're saying, yes, we look at the prison.
I think in this situation, you have
So
to
how
look
does
at the
that help
prison. And in Sandin, the court did say, like, you look at the prison environment. For the de minimis exception, though, even if a procedural due process protection does exist, the court then goes on to look at whether it's de minimis. And here, the imposition, even
Can
in
I
the
ask
context of
why?
the prison environment.
The Constitution says property. It doesn't say property as long as a court concludes the amount of property is more than de minimis. Now, let me just posit. I think the fact this is a teeny tiny amount of money could make a gigantic difference in assessing how much process is due, but I don't understand how it goes to whether you have a property interest at all.
So even if there is a property interest that is recognized, Judge Heitens, this court, for instance, in the Garrity case, has said that even if there is one recognized, you then look to whether that interest is de minimis.
We've said that in a property case, or we've said that in Sandin about liberty cases?
So in Sandin, that is about liberty, but specifically in the Garrity against Jordan case, that was a property case. It was not in the prison in context. It was a property interest found in continued employment.
Could you refresh my recollection? What is the site of that case?
Yes, that's Garrity against Jordan, 830 F. 2nd at 1299. It's a 1997 case, and there the court found that it was not a de minimis imposition, but that still shows, even if there is an interest, the court looks to whether it's de minimis before turning to what procedures
Are
would
there
do.
other contexts where we apply a like de minimis exception to constitutional provisions? I mean, I totally take Judge Heighten's point that when we ask what process is due, the nature of your interest has to have a significant influence, right? And so if we're gonna take $5,000 from a prisoner, the type of process that is due could obviously look quite different than the $7 we've got here. But what other contexts do we like lawfully and reasonably sort of say, you know, the government's only like sort of violated their constitutional rights, so it doesn't matter?
The de minimis exception is well established, certainly under the Hewitt lines of property cases, and then liberty and property cases like Sandin. Sandin then says whether it's atypical.
So the liberty
completion
cases
and-
seem to me
yes.
like fundamentally different. So on the, but I'm actually asking broadly, like outside of the due process context, are there other constitutional areas where we say, as long as the government just violates your rights a little bit, it's okay?
Certainly
Like
not
in a de
necessarily
minimis context?
in those words, and I'm not aware of a specific de minimis rule elsewhere in the Constitution, certainly none that would come into place here. But
So,
there
Mr.
are
Henry, can I give you the hypo then that really troubles me? Because if there is a de minimis exception, so you started by telling me, and I have no reason to doubt it, that in this case, the guy got a hearing, and in this case, he could present evidence, and in this case, but if there is truly a de minimis exception, this means the amount of process due constitutionally is 0, correct?
It would be.
Okay,
under
so
that rule.
that means that if $5 to a prisoner was de minimis, the prisoner could wake up one morning thinking he has $100 in his account, be told he now has $95 in his account, and he could say, what happened to that $5? And the prison could say, shut up, I don't have to tell you, I took it because I wanted to. If that's not property, they can do that, right?
That would absolutely not be the case, Your Honor.
Why not?
It
If
would
it's a de
not
minimis
offend.
amount of-
So he wouldn't be able to say that the prison could just do this for whatever. It would not offend the Constitution, but there are ample other provisions.
So as a matter of the
protections
due
for there.
process clause, they could just say, shut up, we took it.
Under the Supreme Court's jurisprudence, yes, in that
Doesn't that seem
situation.
deeply, doesn't any line of thinking that suggests you can terminate someone's ownership of money and respond, shut up, I can do what I want, can't possibly be what the due process clause means?
And of course, there's going to be a reason for any type of taking of money in that.
But the Constitution would say you don't, the whole point, I mean, Judge Richardson mentioned other contexts, like, it's analogous under the Fourth Amendment, if you say something's not a search, the Fourth Amendment doesn't care about it. And under the due process clause, if it's not property, the due process clause doesn't care about it at all.
And not every case would be a constitutional case, yet the prisoner would still absolutely
I
have
guess
a
what you
remedy.
would say to that is like, yeah, that's like the way prison works, right? That like if you keep money under your mattress, right, they can just take it and you get no process. right?
Exactly.
That, like, there are a variety of contexts that like, yeah, you just get no process. I thought you would just say, yes, that's unfortunate, right? We hope that doesn't happen. We try to hire and train good guards, but yes, that'd be really bad, but it wouldn't violate the Constitution. Just like the money under the mattress or the like extra, package of ramen noodles that they weren't entitled to.
Yes, in those cases with contraband, that's
Well,
absolutely
Mr. Henry,
the case.
sorry, can
and
I,
it's-
I'm not talking about contraband. I'm talking about a prison account that he's lawfully allowed to own, and he just wakes up one morning and is told there's $5 fewer. Your view is they can do that. It's not contraband, in my hypo.
Under the established precedent we have under the property portions of the Constitution, that would be true, but absolutely the prisoner would have other remedies. I mean, the Virginia Tort Claims Act, in that case where there's no justification whatsoever, would allow tort actions against the
What
government.
is the
for cover
largest
that.
fine that you know of that a court of appeals has ever said is de minimis? I'm not talking about district court cases, I'm talking about courts of appeals.
I would point the court to the Northern v. Nelson case in the Ninth Circuit, where that was, in 2024 money, an $8 fine was held to be, or deprivation of newspapers worth about $8 in current money would be worth, was de minimis in that case.
And was the deprivation were those newspapers contraband?
I believe so, Your Honor, so that would
Okay,
be.
what's the largest amount where someone has seized something that isn't contraband and a court of appeals has said it's de minimis?
And of course, there are very few of these de minimis cases that make it up to published federal appellate precedent, but Judge Easterbrook in the Seventh Circuit in the Abdul Wadud case found a 50-cent fine at that time to be de minimis. And that was similar to what we had here, where it was the lowest level of prison offense in the prison system, where the only possible punishments were a reprimand, a small fine, loss of privileges. And of course, the constitutional.
What about the Reynolds versus Wagner case in the Third Circuit?
And that's true. There's several of the cases here.
How
Your
much
Honor.
was in that case?
I don't recall off the top of my head, Your Honor.
It's about $10, $3 or so?
Yes,
Third
these
Circuit said that inmates have a property interest in that amount.
yes. So
What about the Burns case?
agreed. Many circuits have found that there is a property interest, and here there
I was
is.
just dealing with it in context of Judge
Yes.
Hyde's question. You went on the upper end. I'm saying go to the lower end.
Yeah.
What is the lowest amount that a court has considered to be de minimis? The question really is going at is when is it no longer de minimis in your view, in the government's view? When is
And
it?
certainly in
if
this.
you're saying 7 or 15 is de minimis, when won't it be de minimis?
There's no need for this court to draw the line in this case, but I think a helpful reference is the fact that the Virginia Department of Corrections gives every prisoner upon discharge $25 freely if they don't have that in their account. And so in the Virginia context, I think $25 is a helpful benchmark to refer to. This court need not reach the complex constitutional questions
That
here if
makes
it doesn't.
not de minimis, the fact that Virginia gives you $25, and if it costs you $30 to get a candy bar, that wouldn't be de minimis? That would be de minimis?
This is all drawing lines and looking at different amounts.
But I'm only
I don't
using an
think it's-
example. You gave that $25.
I did.
Giving some money would make it de minimis. I mean, $25 would for $15 makes that de minimis.
I would say that would just be helpful reference. If the state freely gives you that amount of money in the prison context, that would help consider drawing lines. But there's no need to draw those lines here for two reasons. First, qualified immunity applies and keeps us from having to look into any.
Did you
of these
ever
issues.
say the words qualified immunity in the district court?
We did not, but a
And don't
crucial.
our cases say that if you never say the words qualified immunity in the district court, you don't get to say them for the first time on appeal?
Crucially, in Sales and Suarez, in those cases, the defendants were the appellants and had the burden on appeal, but it's established.
The answer is yes. But why don't you go to the elephant in the room
So-
in your case, and that's the harmless error review here.
Exactly, Your Honor, and that would be the second.
Is that an affirmative defense, or is that something that has to be pled? Who bears the burden?
Harmless error is not an affirmative defense. That's something that is part of every analysis that the court makes in a constitutional context. And here, as in the Harmon case,
So in your view, it's a pleading requirement.
yes. And I note that on the reply brief here on appeal, even my friends on the other side did not contest any part of our harmless error analysis in the briefing before this court. Here, at no
Help me
point,
understand that just for a second. You think it's a pleading requirement in essence because it's like, in effect, pleading an injury? Right? That if you can't show that the process denial mattered, then there's no injury from the denial of process. So it's almost like a standing requirement.
precisely, Judge Richardson, for any injury to exist, for there to be a harm, the court has to, or the petitioner would have to look at what the prejudice is. And here, in nowhere, in none of the pleading, does Mr. Brown point to how getting any of the stuff that he alleges that he was denied would have changed anything in his hearing or aided his defense, which is our standard for looking at harmless error cases.
I've not thought about this before, but it strikes me that this is like a standing inquiry, right? That in fact, this is like a jurisdictional problem, right? That if he has not alleged an injury, right, he had a fine, that's true, but he's got to allege that the process, the thing that he has alleged was done wrong, caused an injury, right? And so,
Precisely.
is that a jurisdictional problem that we've got to address?
I don't know that the court has treated it as specifically jurisdictional in the precedent, but it's well established that for there to be any sort of harm, there must be prejudice. And at no point in this case has my friend on the other side identified how he was prejudiced by his alleged deprivations. The gravamen of the offense was
Well,
to...
it all premised upon the fact that you are saying they have that burden, but in our criminal cases, when we're dealing with a procedural error, isn't it true that we put that burden of harmless error on the government?
And this court, in its cases, looking at what sort of defenses have to be raised and when, even in, I believe, Sales, has said that we don't require every affirmative defense to be pled immediately at every opportunity. And here, there was a single pleading that the prison officials had a chance to file before the case was dismissed for
Well,
the
the
reason
question
they alleged.
is it a defense? I mean, if I say harmless error, usually the burden is on the party that has alleged the harm. So,
Well,
in this instance here, that did the alleged harm. And in this instance here, usually the burden would be on you to come forth and to indicate that it's harmless error. So if you start with the proposition it's on them, yeah, if they didn't plead it, it's not there, it's a clean-cut way to go. But if you must come forth and indicate, well, there's no harm here. And here, the procedure error, if any, and I think the plaintiff agreed, would be the exclusion of evidence. And the question is, what would these witnesses and these documents and these videos show? And it seems to me, without even pushing you in this direction, but I'm just saying, it seems to me, because this is a transparent proceeding, we're not playing games here. It seems to me that that evidence would probably go, I don't know where it's gonna go to, because the rule says you can't wear a mask, and you only got one exception. And I don't know what a witness is gonna do to overcome that one exception.
I think that's exactly the case, Your Honor, here. There's simply no evidence anywhere of nothing that's been proffered to show what any of the extra processes that he asks to receive would have done to aid his defense. It follows that even if there was any sort of deprivation at this hearing, that deprivation would have been harmless. It would not have affected the outcome in any way.
Of course, it's hard when you're coming on appeal and it says, you didn't let us have witnesses, that sort of, normally, I mean, if it's not pro se, you would want them to proffer what the witness would say, or to indicate what the documents may be known what's there, but in terms of how it could help or not, but we don't know, I mean, what these witnesses would say, at least I don't think the record here shows it.
It certainly does not show it here. He simply says that I requested these forms, and he alleges that he was denied the forms that would be used to get the sorts of evidence and witnesses that he was asking for. At no point does he suggest what they would have said or how they would have helped him. And just to a point that my friend mentioned in his opening argument, that he was a recent transfer and had no notice of this rule and was blindsided by it. Mr. Brown was transferred from Nottoway Correctional Center to the facility where he was at, Red Onion. This rule was one that was promulgated to all of the inmate population of the Virginia Department of Corrections, so he would have had notice at his previous facility.
You'd only need to read the Gaston versus Taylor case to indicate ignorance of the rule of the prison is not going to be a defense.
Exactly, Judge Wynn.
Where you going with it, you don't need to go there.
It's more just as a factual matter. It's very unlikely he truly was unaware of it, even as alleged. And in my brief remaining time, I'd like to touch upon the excessive fines claim, primarily the claim that seems to have only been raised here on appeal. There's nowhere in any of the pleadings below that the pro se litigant, even viewing the complaint and liberally and construing it in the way this court has said we must construe pro se pleadings, nothing in the pleadings set forth an excessive fines claim. Nothing in those cases, or nothing in the pleadings suggests that he's challenging the amount of the fine, that it was excessive, that it was unduly burdensome on him. Indeed, he actually wrote in a letter that's in the record to the correction officials saying that this case is not about the $7, emphasizing that he was talking about the procedure, but not challenging the amount of the
Should
fine.
we be liberal about that?
Yes, even viewing it liberally, though, this court has always looked for some sort of textual hook. For instance, in Slade, the court found that there was no takings claim alleged in the pro se pleading, and it specifically noted that the words property, taking, just compensation, none of those trigger words were there. Likewise here, there are no words that would suggest that there's an excessive fines claim pleaded here, and certainly there's no precedent that would show that the excessive fines clause even applies in this context. At bottom, this case is about someone who violated a minor prison rule and received a minor fine. The punishment fit the offense. He received all the process that he was due with his notice and hearing, and in any event, any denial was harmless error. I ask that this court affirm the district court's ruling.
All right, thank you very much. Mr. Schwartz, you have a few minutes. I'm sorry, Mr. Weiss, I'm going back to the previous case.
It's okay, I don't
You have
mind.
much easier names to pronounce in the second case.
Thank you. Thank you, Your Honor. So just to jump right to harmless error, I say that there's a few different points. So at JA 48, what he alleges is
Who's the
that
burden on?
it might be ambiguous and it might be in fact on us, and I don't think that it matters.
But it seems like you have to do something. I mean, maybe not say it's not harmless, but at least if you want to have witnesses, documents, and videos, it should be more than I just want some evidence in. You ought to say something the evidence is going to show to help you in your defense, and the charge here is your client was not wearing a mask during the time he should, and there's one exception. So how is it going to help to have these witnesses deal with that exception?
I think in a few different ways. So first, I would say at JA 48, what he alleges, and this is a brief pro se complaint, but he says the hearing officer disregarded that there was a conflict between my testimony and the offense report, which is to say what he alleged was that I told my version of events, and then there was the offense report from the officer Branham, and the hearing officer believed Branham. So what other witnesses could do is they could testify and say Brown's version of events is true.
What was Brown's version of events? Did he say he was wearing the mask?
He said that he was wearing the mask. Or no, he didn't say that he was wearing the mask. Sorry, I misheard it. No, he didn't say that he was wearing the mask. It doesn't spell out exactly what that discrepancy is. But just that there was some testimonial discrepancy that the hearing officer credited the officer report and not him.
But I don't understand that. I mean, you said he's not wearing a mask. There's one exception. So what is a witness going to do to testify regarding that one exception?
So I think
The exception being that an officer told him he could take it off. That doesn't exist here. So how are you going to get there?
right. I think to zoom out a tiny bit on the context of this, I believe it is defendant's position. I don't want to mischaracterize it, but if they're saying that this is a strict liability rule, then if he had a seizure and the mask had fallen down, he'd be guilty. And any testimony about the fact that he had a seizure, tough, minor offense, minor punishment. If another prisoner had,
If you're going too fast for a good reason.
You say the witnesses say he had a seizure?
no, of course not.
What did the witnesses say? I mean, that
What-
truly
what-
would
what
be
the
an
wit-
extraordinary situation, but
Your
I
Honor-
don't know anything the witnesses are saying outside of.
Your Honor, I think that this is genuinely an extraordinary situation. He goes to a prison. The prison takes people, the prison takes people who do not follow grooming standards. It is obligated to shave. They have a grooming violators unit in their supermax prison. They take people who refuse to shave and put them in solitary confinement. The prison operates a barbershop. It is inherent. It employs somebody to shave people. And then, so if he had not shaved, he could be
But the rule would
fined.
seem to suggest in that situation, you easily fix that. You're getting ready to be shaved. I'm sure there's a prison staff person in there. They're not letting prisoners shave in a place with a razor without another officer. You turn to that officer and you say, "Officer, I need to take my mask off to be shaved."
The
That's
allegations.
probably what usually happens.
The allegations are that the prison the prison disciplinary officers, or not the disciplinary officers, sorry, the prison staff watched this happen. And it's inherent, if a prison is going to operate a barbershop and punish people for having a beard and also punish people for going to the barbershop that they are operating, it's just, we're into sort of a Kafkaesque place here. And the idea that if testimony had come out about what exactly had, and what I mentioned the seizure, not because that's what happened, but because there has to be some kind of mens rea
I
requirement.
see where you're going. You're saying he's getting ready to be shaved. The officer's sitting there looking at him, and he sees the mask on the officer. He's sort of implicitly or whatever, he's kind of acquiesced.
Right.
That's where you're going with it.
Right, and to perhaps offer the fundamental point, why is the prison operating a barbershop that provides shaves if it is in fact a violation of prison rules to
shave with
have
a
those
mask on,
shaves? You cannot shave with the mask on.
Might just need a goatee then.
That's a constitutional violation of a different type, I think.
All right, we got your point.
Okay, thank you so much.
All right, counsel, we're going to come down and greet counsel and proceed to our final case of the day.
Amazingly, Jay said the same thing to me. Sometimes you see the iceberg coming. I'm not sure that's right on
This
four.
is going to be, we'll see. We'll see. All right, we'll proceed to the final case of the day, TM versus University of Maryland Medical System. We'll hear from you, Mr. Shepard.
Good morning, Your Honors. May it please the Court, I'm here on behalf of the appellants, which in this case are referred to by initials, TM, JM, and AM. A core requirement of application of the Rooker-Feldman doctrine is that the plaintiff must be complaining about an injury that arises from the state court order itself.
Let's start with the basis here.
Yes.
Tell us what the Rooker-Fellow document is, so we'll know which part of it you're talking about, and then the
Yes,
parts
Your Honor.
that you contend
Rook-
not applicable here.
Rooker-Feldman derives from 28 U.S.C. 1257A, which, as the Court knows, reserves unto the Supreme Court exclusive jurisdiction over the final decision of a state court decision from the highest court from which a decision can be had. That's essentially the Rooker-Feldman doctrine in a nutshell.
It feels like if that was an absolute requirement, the Exxon opinion could have been a lot shorter, right? Because in Exxon, there was no state court judgment. So if that was an absolute requirement, we could have just cut out virtually everything in Exxon.
Which requirement?
There was no final state court judgment in Exxon. So if that was an absolute requirement, the court could have said, Rooker-Feld, it is an absolute requirement that you have a final state court judgment. In this case, there is no final state court judgment. Case is over.
It could have been, and
It seems strange the Supreme Court wrote a heck of a lot more than that in Exxon.
it did. And this court in Thana,
This is the where we're musing.
yes, the other side says you were musing, or the court says you were musing.
The court said it was musing, right?
Yes. I didn't really take it that way. I thought the court was commenting on.
You thought the court was like misrepresenting itself?
No,
Right?
no, just the
Court
opposite.
said that's what it was doing.
No. Oh, I didn't know
I
that
mean,
the
the
court
court-
was
the court's
musing.
like-
I didn't read that I didn't see that in the opinion that the court, it said it was amusing.
No, well, it did, I don't
what-
think
what
it
the
used the word musing.
What the
but-
court said is if you read the statute literally, then it would require
And yet the opinion
a
kept
decision
going.
by the Supreme Court of Maryland.
Can I ask you, so your brief fails to discuss the prayer for relief at all. Do you have a copy of the complaint in front of you?
I do.
Great. Could we turn to page, this is going to be JA 48, it's stamped page 39.
Yes. I'm there.
Okay. So can we agree that with the exception of maybe D, if I squint really, really hard, there's no request for damages in this complaint? I see declare, grant preliminary and permanent injunctive relief, right? That at least in A, B, and C, I see declare, and injunctive relief.
I think that's correct.
Okay. And when I look at A, B, and C, I look at what you're asking me to declare and to enjoin, and do you agree with me that the words consent order are in every single one of those paragraphs?
I do, and may I address
Please,
that?
yeah. Mhm.
Okay. I think the case that explains our position the best is the Sung Cho case out of the Second Circuit. Now, they're applying a formula that they derived in a case called Hull Block, which this court applied in Hulsey versus Sissa. Like the Second Circuit in Sung Cho.
Was there a consent order in Sun Cho?
Yes,
No, there was a judicially approved settlement agreement in Sun Cho.
that's exactly what
Those are
we.
not the same thing, are they?
Well, they are, and in
Can you be
fact,
held in contempt for violating a judicially approved settlement?
if the settlement terms are incorporated into
A
an
consent
order, yes.
Okay, but Sun Cho says over and over again, it was endorsed so ordered by the court. A
Correct.
court ordered, so let me give an example. For a minor or an infant or an incapacitated person, it's entirely possible you need judicial approval of a settlement, right?
Yes.
But it's not contempt to violate a settlement agreement, is it?
Well, take the divorce context, where the settlement agreement is often incorporated into a divorce decree.
Okay.
You absolutely can be held in contempt under those circumstances. That's what we have here. And in fact, Your Honor, I plead that.
What was the state judge also signing this then? I mean, five lawyers signed it and a state judge.
The state judge ratified it, is what they did. And
So it's not the same as a judicial decree that indicates it's
well, it's a judicial decree, but it's also one that incorporates the settlement agreement between the parties. And if I may get very specific with the allegations, because I want to make sure I address Judge Hayton's, where he's going. If you look at paragraphs 182, 191, and 199 of the complaint, those 182 says that the consent order contained the negotiated settlement agreement. In other words, that was the agreement between counsel and the hospital that was put into the consent order. We also allege that we agreed to those.
I have actually a directly responsive to that. Does the agreement, do we know, this is an honest question, I don't know the answer.
Sure.
I'm sitting here right now. What if, counterfactually, the court had refused to enter into the consent decree? Does the parties' private agreement say what happens if the court refuses to enter a consent order?
No.
Does it have any legal effect absent the court consent order?
Yes.
I guess I'll think of like a plea bargain, right? So like the government and the defense
Well-
can agree to any old thing they want, but until a court accepts their guilty plea, the
No,
agreement doesn't do anything.
I would say that the agreement between the parties would have been enforceable as a contract.
Okay.
If the court had said, I'm not gonna enter this as a consent order, and that's the whole point that I'm trying to make, is that the harm arises from the settlement agreement between the parties, not what the court did. And that's what the Sung Cho case teaches us. And specifically in paragraph 199, we allege that it was the actions of the hospital in demanding these settlement terms that harmed us, not what the court did. The court just put a stamp on it.
So let me posit that I think to the extent the actions of the hospital in the negotiations harmed your client in a legally cognizable way, that she could get damages, but this complaint does not seek damages. So let me ask you then, could you identify what is the harm, the legally cognizable harm, that you are seeking to have remedied by a declaratory judgment or an injunction?
Right. Two parts. First, I want to point out that in the Sung Cho case, I know the other side makes it a big point about
I'm not asking
the
about
remedy.
Sung Cho, I'm asking about your case.
I understand, but the reason I'm bringing up Sung Cho is that in that case, they asked for the exact same remedies that we do, a permanent injunction and a declaration that the agreement is invalid.
They asked for one other thing, didn't they?
Well, they asked
Having
for
read Sung Cho this morning-
de minimis damages.
They asked for nominal damages.
Right. Now, we filed a separate lawsuit in which we asked for damages,
And
which
does-
could have been consolidated with this
And
one.
would you agree with me?
Yes.
That Sun Cho at no point differentiates remedy by remedy? It never asks, like, it just says the lawsuit could go forward. It doesn't go remedy by remedy.
You're right.
Okay, so I want to bring you back to my question.
Yes.
What harm do you believe would be remedied by the grant of injunctive or declaratory relief in this case?
It would nullify the settlement agreement between the parties, which we
And which
believe.
would do what?
Well, right now, my client has to give up her primary healthcare doctor of her choice.
Okay.
She has to use certain providers dictated by the state for the rest of her life.
And when we say has to, we mean what would happen if she didn't?
She would be in breach of contract. She would also be potentially held in contempt of court.
Okay, but I guess I'll say is, here's the way to think about it. Even if we were to hypothetically nullify any contractual obligation that existed,
Yeah.
we'd have to also act on the consent decree or she'd still be in contempt of court, right?
Yes, the Supreme Court's explained that a consent decree has aspects of a contract,
Aspects, yes.
right? And also aspects of a judicial order.
Right.
Right. And in this case, they're one and the
But
same.
so you are in fact trying to backdoor attack the consent decree, because if the consent decree remains in effect, she can't do any of the things that she wants to do unless you get rid of the consent decree.
A court wouldn't have the authority to enter a consent decree absent the underlying agreement of the parties. What we're saying is that the underlying
say-
agreement of the parties is where the harm came from, not the fact that the court simply put its
I guess
stamp on it.
Again, damages I think are separate. I totally understand why you have a separate lawsuit for damages, but when it comes to the harms that are in many ways caused by the consent decree, why isn't the answer, these sound like great arguments to make in Maryland State Court?
Well, they could be great arguments in Maryland State Court, but
And the only reason the Maryland State Courts haven't decided them is because your client got a stay of the State Court appeal.
well, that brings me to the next thing, is that this court has made clear that Rooker-Feldman doesn't apply. It applies only to final decisions.
But you're saying you're the one that made it not final.
Well, we don't have the authority to make it not final. We requested a stay to give the federal court. The federal court was farther along than if we had, we filed the appeal only to protect our interests, okay, which is perfectly fine. But the federal
It's
court.
just a little bit weird to say, you can't do it here because we don't have a final state judgment. Don't pay very much attention, though, to why we don't have a final state judgment, because it.
No. I'm not saying that. We're perfectly with, the court control, I don't have the authority to tell the Court of Appeal, or the Maryland Appellate Courts what to stay, but the important point here is, every circuit, and I mean every circuit that's addressed the issue of whether you can apply Rooker-Feldman when there's a state appeal pending, state or not, because the judge here said it doesn't matter whether it's state. The fact that there's an appeal doesn't matter.
What about the Sixth? You said every court, as
Right,
like,
the
but
first-
Sixth Circuit.
No, I'm saying every court that's addressed it. I don't think the Sixth Circuit has,
Really? I thought they had a whole opinion about this.
I'm not aware of it. I'm aware of the 1st, 3rd, 5th, 7th, 8th, 9th, 10th, and 11th. And they've all said, when you have an appeal pending, it's not over. And if you look at the orders that the state court imposed, it didn't say indefinite. This is not a permanent stay. Those orders are in the appendix to the opening brief. All of them are. They all have the same language. It's only stayed pending further order of the appellate court, and it's tied to either a decision by the federal court or 120 days. So by definition, the court is saying, we're only staying this for a period of 120 days. We'll reassess it at that time. And at any time, the appellate court remains free to reinstate the appeal. So we don't have a final decision from the state, no matter how you dice it.
So, okay, so for benefit of your rebuttal time, the case I'm talking about, the Sixth Circuit decision, is RLR Investments for F4 380, which I think says not what you want us to say.
Well, there are cases, even the First Circuit, which is the one they rely on, have said you can have finality under certain circumstances. So if the Sixth Circuit says that you can have finality during a state court appeal, that would be contrary to the 3rd, 5th, 7th, 8th, 9th, 10th, and 11th circuits. And I cite all of those cases on page 6 of my reply brief, so to give you all the citations. So they would definitely, I'm not familiar with the case, but if in fact that's what it says, that it would definitely be in the minority here. Every case that I'm aware of that says you have to have a final or a final decision that is considered a pending state appeal has come down saying that you cannot apply Rooker-Feldman without a final order.
I would urge you very much to respond to the argument on your rebuttal time, because the Sixth Circuit expressly says there's no finality requirement.
That there's no, well
There's
then,
no finality requirement.
well then they're,
I understand the
I
finality
can
requirement.
I can say,
That's why it's wrong.
this court, well, it's wrong because the Supreme Court says the statute itself says you have to have a final order from the highest court of the state in which a decision can be had, so you got the plain language of the statute. This court in Jonathan versus Justice just a couple of years ago said you have to have a final judgment. There was no state pending appeal in that case, so we don't know whether that would change the analysis. But what I am saying to you is, just because I'm going to assume that the Sixth Circuit says you can have a pending state appeal and have enough finality for purposes of Rooker-Feldman. If that's the Sixth Circuit's position, it is contrary to every other circuit court that I've listed on page 6 of my brief, and I would suggest that it's contrary to the instructions from the Supreme Court. Keep in mind that the United States Supreme Court has instructed lower federal courts to cabin Rooker-Feldman to the procedural cases that mirror Rooker and Feldman themselves.
Is that what it says, or it says cases of the kind that were Rooker and Feldman? I believe that's the language.
Well, the language, this court has interpreted it as cases that mirror procedurally those cases that gave rise to the Rooker-Feldman doctrine, the Rooker case and the Feldman case.
Why did you ask for a stay of the matter in the state court?
The appeal we noted was a protective one. I didn't know how the federal court would rule, but the federal court was way far along, and I filed the.
But you got a matter in state court, clearly a state matter, and that matter is being applied in state court. It's on appeal to the state courts. You then seek, as you've done here, you seek to get remedy in the federal court here, but you got a state matter going on. So
Right.
you are saying that the way to avoid finality is you, as the plaintiff, would file a stay.
There is no, Your Honor, respectfully, the Supreme Court has made it very clear that there's no problem with having parallel state and federal proceedings on the same issue going at the same time. When one or the other makes a decision, it would be perhaps preclusive of the other.
Doesn't a stay frustrate finality?
No, it doesn't mean that the state appeal is over. It just means that it's temporarily stayed.
What happens if you didn't file a stay? What would be?
Well, I mean, the court,
You probably have something coming from the court there by now.
well, I don't know about that, perhaps, but at the time that we requested the stay, the motion had been pending before the district court for well over 5 months, fully briefed.
What happens if we decide to stay this pending appeal, pending this matter in the state court?
Well, then I would go back to the state court and say, then we have to go forward. Somebody's got to decide it.
Isn't that what you ought to do?
I don't think so, Your Honor, but I mean,
If you want to be with the principles of the Rooker-Feldman doctrine, the whole purpose of it is, we can't be second-guessing decisions of the state court. That's the United States Supreme Court can do it, but only in exceptional circumstances do we do it, in habeas and maybe in the Florida case that dealt with Terry Schiavo, and cases like that, we've been in that situation, but we don't do that here. I mean, practically speaking, think about it. Could we just, on our own, just say, no, we're gonna stay doing anything pending that? Would we ever see this case again?
if the court entered a stay,
Yeah, and so pending
You-
what
you-
goes on there, which essentially lifts up this, I would think, the essence would be, we can write it in, it lifts the stay that you have there, state court, go ahead and decide the stay. What if we just certify this whole thing to the highest court, this issue of whether this consent thing is done with?
you could do that.
It
But-
belongs
but-
in state court.
but-
It belongs in state court,
Well,
not here.
Your Honor,
You want to be here because you didn't get the remedy in
No.
state court.
I never asked the court for a remedy. I never asked the state court for a remedy.
That's exactly
But-
what Judge Hyde pointed out on your complaint.
Right,
I'm
but
not sure what remedy you are seeking here,
I'm seeking to have,
other than the point out to the consent decree, which makes that the injury. Is that the injury? The
The
consent
consent
order is that the injury?
the injury is requiring my client to give up constitutional rights to gain her freedom from the hospital. That's something the hospital did. The court didn't do that, okay?
But it arises from a consent order, that requirement. So the injury is a consent order, and you seek to get rid of the consent order to say you're entitled to deliberate the interests under the 14th Amendment.
Your Honor, I seek to get rid of the underlying agreement, which is embodied, in this case, in a consent decree. If there were no consent decree, and we just had a settlement agreement in which she was required to give up those rights, I would be complaining that state actors required her to give up her constitutional rights in order to get her freedom. It would be the same.
Okay, let's hear from Mr. Sardek, and you will have some additional time to speak.
Thank you, Your Honor.
Thank you.
Good morning, Your Honors. I'm Mark Sodek. I represent appellants in this action, University of Maryland Medical System Corporation, Baltimore Washington Medical Center, Inc., Kathleen McCullum, and Thomas J. Cummings, Jr., MD. This case presents a straightforward application of the Rooker-Feldman Doctrine as set forth in Rooker, Feldman, and as clarified by the Exxon case in 2005. Under Rooker v. Feldman, and this case is procedurally similar to the Rooker v. Feldman case in that the plaintiff is not bringing, appellant here, is not bringing a parallel action, is not bringing an action to challenge the same conduct in federal court as in state court. In this action, plaintiff has brought a claim to challenge directly the state court order, the consent order that Your Honors have heard about.
Can you help me with this one? So we said in Del Webb versus Carlson that you're not a state court loser for purposes of Exxon and Rooker-Feldman if you got what you asked for, right? In that case, they were seeking arbitration. They got arbitration, so they weren't a state court loser. And so we said they didn't get the benefit of Rooker-Feldman. You sort of got, I mean, in this case, we've got the same sort of problem, right? That TM sought a consent decree and got the consent decree. And so why do we think that she's a state court loser? She got what she asked for, a consent order.
She got what she asked for in the form of the consent order. She now asserts that she is the state court loser. TM challenges the order itself.
I understand that, but the rule is that we've got to have, maybe the rule is, you got to be a state court loser. What I'm trying to understand is whether we can call her a state court loser since she asked for the consent order that she got.
Yes, Your Honor. In this instance, after the entry of the consent order, TM does believe that she is the loser in state court. That is why she has challenged the order in federal court.
We don't typically think about somebody like prevailing or losing based on their subjective after-the-fact perception, right? I mean, I take it in Del Webb, right? The reason that the person who had sought arbitration was in federal court is because they regretted their decision to ask for arbitration. That's why they were there, right? They thought subjectively on the back end that they lost, right? But that's not really how we do it. And I take Carlson to be saying that if you get what you've asked for, then you are not a state court loser. And what I'm asking is, why is that not the case here when she asked for a consent order? And that seems to be what she got.
Yes, Your Honor. In this instance, TM alleges that she did not voluntarily seek the consent order, that she was under duress, she was coerced, and therefore the consent that she provided for the consent order was not in fact valid. I believe that is the answer that TM would provide as to why.
In other words, she's saying she didn't ask for this. It was under duress, and that's her defense to part, at least in the state court. And so Judge Richardson brings up a good point. I mean, if it's a consent thing, you come up here, it really brings the question, do non-adversarial state proceedings implicate the Rooker-Feldman Act? And your nuance seems to be, well, this isn't exactly non-adversarial. The consent agreement itself, if you took the fact that she voluntarily did it, then yes. But she says she didn't. She says it's a duress thing, and I didn't get what I wanted for it. You gave me something I didn't ask for, which presents, I think, a rather novel question for us to consider. That's probably the reason we're here listening to your case right now. And that's the point that Judge Richardson's making here. So address that further if you want.
Well, certainly the underlying state court action was adversarial. In that action, there was not agreement, of course, and the action would have moved forward had the parties not reached a...
So we understand, we're talking, the consent agreement in and of itself on its face looks to be non-adversarial. I mean, that's what a consent agreement is. But when you bring an action, or at least take an appeal from that, your contention is, I didn't agree to it, and therefore this is something somebody did, and it wasn't me. That's what duress is. It means either I did it under pressure or some kind of coercion or whatever, and it's not me. It's an interesting nuance, and maybe Judge Richardson is on something here. I'm trying to walk through it.
In any event, this was an order issued by the court, and that is the order that is being challenged. And by challenging it, the Johnson v. Orr case in the Seventh Circuit looked at a consent order as well, an agreement between the parties, and held that even where the parties have agreed to the relief that would be provided, if that relief is later challenged, that renders the person who challenged it the state court loser. And so even though we have the agreement...
So your view is that we look at who's a state court loser based on their sort of subjective view at the time the federal suit is at issue? I mean, that doesn't seem like what we did in Carlson, right? Like that seems like that would lead to a different result in Carlson, right? Because they wanted the arbitration then, right? They decided they didn't want it anymore, but they were still got what they had asked for.
Yes, Your Honor, we would do that, at least in the limited circumstance where the party contesting the order asserts that they did so under duress, and therefore any consent that they provided at the time was not valid consent. And therefore the consent at the time the order was entered did not in fact indicate their assent to the relief that was provided.
Was the person in Carlson seeking to modify or enjoin the actual state court judgment in any way?
Your Honor, I'm not aware of the answer to that question.
I think the motion, the state court order in Carlson compelled arbitration, and what the person was asking to do, as I recall, was to address a whole bunch of questions the state court had never addressed.
Yes, Your Honor. In that instance, that then is different from this case in which the state court is directly addressing the underlying complaint that was filed in that action and resolving that complaint in its entirety.
Can I take you to what I think is probably the best case for the other side, and what is your response to Sung Cho? Because I keep reading it, and it definitely has some very obvious similarities to the situation. So you would say, well, either is your position we cannot rule for you without saying Sung Cho is wrong, or do you think we can distinguish Sung Cho on some basis?
We can distinguish Sung Cho on two bases. First, as Your Honor pointed out in the topside argument, there is a difference between the settlement agreement and a consent order. That this case involves a consent order, which is an order of the court, not an adoption or otherwise taking a settlement agreement privately entered between the parties and recognizing it. And
Does that work? I want you to come to the second one, but does that work where it says so ordered? I'm not sure in Sung Cho, doesn't the judge write so ordered on it? Doesn't that feel like it's now like a consent order?
It certainly becomes an order of the court at that point, yes. And this brings us then to the other basis for distinguishing Sung Cho. Sung Cho involved a series of actions by the defendant in which the defendant, the city, required parties to enter into a series of agreements, and then months later, far removed temporally, had the court enter those agreements as orders and then took action to evict tenants from their premises based on the subsequent orders. And in Sung Cho, the plaintiff attacked the underlying settlement agreements. In this case, the attack is on the order itself, not the settlement agreement, or not any agreement between the parties, but the order itself. Sung Cho involved an attack on the underlying conduct, which occurred temporally far remote, months earlier at least. In the case of Sung Cho, the named plaintiff, it occurred months earlier and was temporally and substantively distinct from the act of entering that by the court. In this case, there is a single act that is being attacked by the plaintiff, and that is the entry of the consent order itself. It is not the underlying agreement. There is no underlying agreement. What we have is a consent order presented to the court and then entered immediately by...
As a formal matter, how do I know there isn't an underlying agreement? I mean, one thing that's a bit challenging and a bit frustrating about this case is that the underlying agreement does not appear to be in the record. Is that true?
There is no underlying agreement in the record. That is correct.
Well, or is the consent decree in the record?
There is no consent decree. The only document is the consent order, which
Sorry,
was...
is that document in the record? The consent order. Yes, that's in the record. Okay, but there's nothing before that that's in the record.
Correct. There
Okay.
is no other document. There is no other document in the record. That is correct, Your Honor. So,
And are you, this is always a dangerous game, but I'm gonna ask it anyway. Are you representing that there is no other agreement other than what's in the record?
Your Honor, I am not at liberty to address that question at this point. I think it would be unwise for me to do that. I was not involved at that phase of the proceedings.
Totally fair.
I am
That's a fair
aware,
answer to a slightly unfair question, but I wanted to ask it.
I am aware that the record contains no independent agreement of the parties, only the consent order, which the Circuit Court for Anne Arundel County then entered as an
Well,
order.
then I guess, does the complaint allege the existence of an independent agreement between the parties?
I'm not aware that it does, Your Honor. It does not allege a complaint separate from an agreement separate from the consent
Can I
order.
ask you about my understanding, this would be all publicly available documents. My understanding is there is a separate lawsuit seeking damages.
Yes, Your Honor, that is correct. That lawsuit was filed by TM against the same four defendants in this action, currently appellees. That was filed in the District Court for the District of Maryland.
What is the status of that case?
The Honorable Judge Rubin dismissed that action
Based
on a
on?
Rule 12 motion, failure to state a claim.
So not Rooker-Feldman?
Correct. That case then has now been appealed, and briefing is underway in the Fourth Circuit, this court, on that action. And Your Honor, that is a critical point here, because plaintiff herself has bifurcated her actions. And so that establishes, again, that this is not in fact a challenge to the underlying conduct. The underlying conduct is challenged in both the state court action in which the consent order was issued and in Judge Rubin's, the root case before Judge Rubin.
I have a question, but finish your answer.
And causes of action are pled under three federal discrimination, or three statutes alleging discrimination under three federal statutes, as well as battery and false imprisonment, and damages are sought in that action.
So let me give you a hypo that sort of builds off this. So imagine a world in which the following things all happened, and we can all agree and we can all prove that all these things happened, right? So at some point, someone takes another person into a room, threatens them, beats them up, like commits a tort against them, like an actual actionable tort in law, right? An assault, a violent assault. And then 2 days later, those same two people go into court and agree to a consent decree. And the allegation later is the only reason I ever agreed to that consent decree is because someone beat the heck out of me 2 days ago, right? You agree that person would still, notwithstanding the actually not even a consent decree, like they go into court and the court finds something during a contested proceeding, in part because the victim doesn't testify, and the victim later claims the reason I didn't testify is because someone beat me up, right? You agree that person definitely still has an action for damages later. Like, if the argument is you committed an assault against me in the room before we ever went into court, that person has an action for damages, and Rooker-Feldman has nothing to say about that.
Yes, Your Honor.
Okay.
That person would have an action, certainly in state court under any number of torts and perhaps statutes, and possibly in federal court if the federal court has subject matter jurisdiction.
Even though the beating could also be relevant to the proper outcome of the later proceedings, because the beating could suggest that the court found the facts wrong in the other proceeding.
That is correct. That does not implicate Rooker-Feldman. This case is similar to the Rooker case, because in this case, the plaintiff did not bring parallel actions. So the state court action in which the consent order was issued involved allegations or claims asserting wrongdoing that occurred prior to the consent order and underlying that action. In that case brought in the state circuit court, may be appealed to the intermediate appellate court, the state Supreme Court, and then the United States Supreme Court if it accepts certiorari. What may not happen, and Rooker establishes this, is that where you have a non-parallel federal action, you may not challenge that order directly in district court. That is clear under Rooker, and it is not changed in any way by the rulings in Exxon, which narrowed Rooker and Feldman under other circumstances, where in fact the plaintiff has asserted parallel causes of action. Your Honors, I'm pleased to address both the other allegations with respect to the dismissal of TM or JM and AM. Should this court have any questions, otherwise we will rest.
Let me ask my colleagues anything further. Anything further? Thank you very much.
Thank you, Your Honors.
Mr. Shepard, you have a few minutes. Rebuttal.
Can you start with my good friend Judge Hyten's question? When I read the complaint in paragraph 182, it suggests that there is no separate agreement apart from the the consent order. Is that right?
Let me explain what happened.
Great.
If you read through the record, you'll find that TM was at risk of having against her will, forcibly inject with antipsychotic medication. And she was being held. She was complaining about both. Her lawyers were negotiating with the hospital to try to get her out. That was her goal, to get released from the hospital to avoid those injections. There was an oral agreement reached between the attorneys for the hospital and her attorneys, and that agreement was memorialized in the consent order. There was no time to put it in. They could have, I guess.
No, but the agreement, but as I understand, I understand that, and I understand what we've got here.
Right.
But the agreement was to enter into a consent order. That was what the agreement was.
Well, there was a pending case, Judge, and the parties wanted to get rid of not only that case, but all the other litigation that was pending between the parties. And so part of the agreement was that we'll let you out, but you have to dismiss all these other cases. And that's why that's
and
part.
enter this consent order.
Right, and we're gonna get the court to dismiss this case by presenting our agreement to the court and having the court sign off on it.
But, so then go back to Sung Cho for a minute, right?
Yes.
And so the argument that your colleague is suggesting is that in that case, unlike this case, there were independent agreements that were only later memorialized, where what you have is an agreement that is, I hate to use the word because it gets misused here, but inextricably intertwined with the consent order, right?
Well,
and that is a distinction between these two cases. Can you tell me why you think that distinction is either false or doesn't matter?
I don't think that it's a distinction that matters, Your Honor. You're talking about.
Why not?
Because you're talking about timing. So the circumstance.
Well, it's not just timing, right? It's the existence of an independent agreement, independent from the consent order.
Right.
Or whether you just have a single consent order that by its nature involves an agreement. That's what consent means.
Let's assume that the lawyers reached the agreement over the phone, which is what happened.
Yep.
TM, if you dismiss all these cases and you agree to these terms, we will release you from the hospital. That's what you want. That was the whole purpose of the underlying habeas case. Let's say that they decided to just go in and say to the judge, Your Honor, we've reached an agreement. We're going to dismiss the case, and they presented a different document to the court that had the same terms as the consent order. And the court said, so ordered, just like the judge signed this consent order. I don't see a material distinction between what happened in Sun Cho, other than the timing of the underlying agreement. But we still have the underlying agreement here. Instead of just writing so ordered on the underlying agreement, it happened to be memorialized in the format of a consent order, which the judge simply signed. That's the only difference. And I don't think that's a material difference, Your Honor. I don't think that the other side has distinguished Sung Cho. That's certainly not a material to the legal analysis, because what we're complaining about here is not that the court order harmed us. We're saying that, and if you look at paragraph 199, we expressly allege this. It was the actions of the hospital in demanding those terms of the settlement agreement that caused the harm to my client, not the court simply signing off, or in the words of Sun Cho, saying, so ordered, okay?
What could you appeal from? You appeal from what, the agreement, or you appeal from the court order?
Well, unfortunately, I wish I had a separate agreement.
You can't appeal from the agreement, you have to appeal from the
Well,
court
you
order.
could.
You have to have, it's a matter of semantics, whether the agreement, and then you got an order, and then the question comes up is, what is the underlying rationale for the injury? And
Right.
That arises from a court order. And from the court order, that's what you appeal.
Well, that's the only thing I had in this case, but if I had, let's assume I had the underlying agreement, I
So
could.
your problem is with the court order.
No, I go back to what the Supreme Court said with regard to consent orders. They're two elements. It's not like there was no like judgment, like a trial. There was an agreement between the parties, and that agreement was simply memorialized in that format. Let's assume that the consent order was never entered.
Would that mean that you could never do Rooker-Feldman in a consent order case? Because there's always, in your mind,
no.
consent order by definition includes an agreement, and so
No.
you could always challenge the agreement, so.
No, that's not what I'm saying. If you look at the Johnson versus Orr case, which is what the lower court relied on, what they just argued, there you had a tax sale. The plaintiff got the right to buy a deed at a tax sale. Later, the court said that was a mistake. The clerk said that was a mistake. There were no taxes due. And with the consent of the plaintiff, the court entered an order nullifying the tax sale. So therefore, the plaintiff no longer had a right to get a tax deed. Several years go by, then he sues, never mentions the agreement, and says, I'm suing because the court didn't give me a tax deed. That consent order caused the court not to give him the deed. In other words, the harm arose directly.
That's not a consent order, right?
Sure it was.
He consented to an order.
Right, but in the language of Johnson versus Orr, they're talking about a consent order. Like the plaintiff entered a consent order to dismiss the initial claim.
I understand the argument.
Right.
All right. Thank you very much for your arguments today, gentlemen. We'll come down and greet counsel and adjourn for today.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.